cheesecake.
You should be live.
Okay, so Senate Government Operations, it is Tuesday, April 6th. And we are starting today with looking at the OPR bill. And I'm just going to tell you before we start, first of all, we don't do any chat. So for those of you who like to do chat when you're in meetings, we don't do chat because we consider chat a sidebar conversation. And if we were in the State House in our committee room, we would ask you to leave and have your chat outside. So the only way we use chat is for if Peggy is sitting in today in place of Gail because she couldn't be here, is if somebody refers to a document, she'll post it on chat that or a link, but otherwise we don't use it. The other thing I'm going to say is that at some point I am going to be
Are you okay?
We just got a chat from Joshua Green who said that he, but we don't use chat. So what we can do is if you're doing this between patients, I understand. So I guess the way to do it is, Peggy, can you send him an email when we're, or Josh, you just are going to have to come on because I don't know how we can know when you're between patients. So if you just come, when you're with us, we'll call on you, and when you're not, we won't. Because I don't know how else exactly to do it, because we don't know when you're between patients. But what I'm going to say is that at some point, I'm going to be called over to another committee. So I will pop off for a few minutes and Anthony will take over, and then we'll go. And then I'll come back when they're done with me. It's House Government Operations. So, okay, well, so let's get started. And we thought that we would, there are really 4 issues around the OPR bill. One is the OPR bill itself. And I do not see Heather Scholdice was going to have somebody here at 1:30 to talk to us about the issue of the chain drugstores. So, and I think he has an, Allison, I can't hear you.
That's Mike Duteau. The Vermont Association of Chain Drugstores. I think that's Heather's person.
I don't see him on my screen.
Well, he may. Peggy will keep her eye out for him.
Yeah, if he comes, because he said he has to be back at 2:00. So there's that issue. Jill Olson has raised an issue that we should address. Joshua Green has raised, we're just going to hear what that issue is. And David Englander is not here. So Lauren is going to talk to us about what that issue is. And we're going to see if it's something we want to do. Is this the appropriate place for it? We don't know that. And then we're going to look at a little bit about the criminal records and how the best practices that were sent out, and if any of that can be incorporated into the bill. Does that make sense, committee?
Yes.
Thank you. And excuse me. And I did forget to say that the MMA, and I don't know if you've been able to come up with new fees for the MMA. You were going to work with Rex around new fees, and then you have Beth St. James with us, and I don't know where she fits in what you're talking about. So Lauren, if you can help me there.
Sure, I'd be happy to. Good afternoon. For the record, Lauren Hibbert, Director of the Office of Professional Regulation. I have Beth St. James here with me today. She's our Chief Prosecutor of our enforcement unit. I thought she might be helpful in our conversation about criminal convictions.
Oh, okay, great. Great, okay. So let's start just with a question about, did you come up with new fees yet for the MMA section?
I do not believe that we have new fees
Okay.
for MMA. It's my understanding that the fees are reasonable and based on what has been previously set in statute for boxing. But I do know that that conversation was going to occur, and I will send a message and ask whether that conversation has happened in the
Okay.
interim. And I should have an answer at the end of this committee.
So we'll just pass over that part today then. So let's take, Jill is with us. Let's move to Jill, if that's okay. Jill, are you there? We see your smiling face.
I am here. No, I am here. I just didn't think you'd get to me so fast, so I wasn't quite in position. Just give me a moment.
Well, we
Here we go.
try to, anyway, here you are.
Here I am. There we go. Can you see
Okay.
me?
Yes. So do you and Lauren
Thank
want to address the issue that you brought forth?
Yes. Lauren, do you want me to start? Okay, great. So I'm hoping it's a pretty straightforward issue. Back in March of 2020, we did some great work with the legislature to put in place some flexibilities to help us address workforce shortages in the pandemic. And one of the things that we did was allow for nurses who had lapsed licenses, recently lapsed licenses, to practice during the pandemic. And the flexibility is all in session law. So I think there was a broad understanding that the idea was to extend that flexibility really to any organization, including home health agencies who hire and employ nurses. None of my members ever used that flexibility, and it got extended. It's been extended now, I think twice, or 3 times now, actually, the latest with what was S117 and what is now Act 6 of 2021. But this year, one of my members actually wanted to use it. She hired a nurse with a recently expired license to provide immunizations. So she's helping in her community with immunizations for both homebound Vermonters, but also for with some of the clinics that are happening that are run by other organizations. And when she took a deeper dive into the language, she realized that it references licensed facilities as the entities that can hire nurses with lapsed licenses, but doesn't define the term. So I hadn't noticed this before because we are listed in statute under the, I think it's actually the CON statutes. There's a definition of healthcare facility, and it uses the term facility, but it includes home health. And so I just missed it, honestly, and we didn't catch it until a member actually attempted to use the language. And so she realized that the plain meaning of licensed facility might not totally be clearly applicable to home health agencies. We're actually not technically licensed. We're Medicare certified and we're designated, but not technically licensed. And of course, we don't provide care generally in facilities. We provide care at home. And so the plain meaning of those words might potentially leave a home health agency exposed in a way that I don't think was intended by the law. I think it was intended to be very broad. And you'll actually, if you notice if you look at the bill version of Act 6 in S117, you'll see that, in fact, the FQHCs, the federally qualified health centers, actually added language to specify that they're included in this provision this year. And I actually think there may even be other groups that don't fall under the plain meaning of licensed facility. So really our only ask in our proposal, and I do have some written materials that I've sent to Peggy's just so you can have it left behind, is just to say wherever it says licensed facility and federally qualified health centers, there are 3 instances, to instead say licensed facilities, health facilities as defined under 18 VSA, blah, 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 whatever the section is, I wrote it down, and federally qualified health centers. So just to add that specificity that anybody in that healthcare facility definition is included. 2 important points. I do think you need to leave the phrase licensed facility as is, because there are some facilities that are licensed that are not included in the health facility definition, like residential care homes. And federally qualified health centers are also not included in that definition. So I don't think you want to remove anything that's in the statute or the session law. What I'm asking is you just add in this definition to make it explicit that we're included. I think it was always the intent. I just want to make sure that we don't leave anybody exposed later.
Thank you. Lauren?
Office of Professional Regulation supports this modification, and it certainly was the intent of the law to allow anyone who has this lapsed or inactive license to work in any healthcare setting where they would have appropriate supervision. And I think that's the piece, appropriate supervision, and certainly Jill's clients meet that, and we support this addition.
Any questions, committee? Senator Polina?
I'm just wondering, is this only through the emergency times, through the pandemic times?
Yes.
Okay.
It's through 3/21/2022.
Oh, yes, that's right. That's right. It has a date certain end date so that people can make sure that if they want to renew their license, that they know what their deadline is.
Senator Clarkson?
It's a treat to see Jill. I haven't seen Jill for way long.
It's really nice to see you too.
I wish we were dancing. I'd love to do it, Jill.
Me too.
So the question I have is, does this flexibility, given our shortage of nurses, does this flexibility actually make any sense for us, sort of like our lessons learned bill, to allow us to use it when we need it, instead of just having it end in next March? I mean, is this flexibility useful for us with our workforce shortage?
So I have not asked my members that question in that way, and I would actually want to defer to Lauren on that. I think it's important for people to have active licenses and to meet the requirements of licensure in normal times. We're talking about vaccination clinics, and so that is, which is I think how it's likely to be used. So it is a less complex form of care. But I wouldn't want to speak right now without conferring with Lauren about something more permanent. Certainly, it's the kind of thing we'd want to be able to quickly put into place were we to have another health-related emergency. No question about that. Yeah.
That's sort of more what I meant. Not that we would want to encourage people to not be licensed. We want people to be licensed.
Right.
Lauren, do you want to comment on that?
I agree that it should be in the springing emergency bill if we need to utilize that bill, and hopefully we know that we will, but hopefully we won't have to utilize it soon. This would be a useful addition there. Really what this is going towards is what are the requirements for renewal of a nursing license. And in Vermont, we have an active practice requirement that can preclude people from rejoining the workforce after retirement or extended leave from the profession for a whole variety of reasons. And we have had conversations with the nursing board if there are alternatives to that. And I think that's a really important question, even outside of a pandemic or state of emergency. We want to make sure that the paths back into a profession are appropriate. And we do know that practice hours can be a barrier. So we're working with the nursing board to explore other options, or, a lot of professions have continuing education as proof of continual competency. That's easier to accomplish than clinical hours when you don't have a license. So it's a topic of ongoing conversation. I certainly do not have a recommendation for this committee on that topic today, but it is something that we're looking at and trying to make sure that the barriers to re-entry are reasonable.
Yeah, I would just add to that one thing that we discovered during this first year of our pandemic experience is that we actually had some nurses who would have met their practice requirement, but for the pandemic, during which time their services weren't actually needed as we reduced the services that were being provided all around the state. And so we actually had some nurses who might have come back into the workforce otherwise, but couldn't meet the practice requirement during the pandemic year.
Senator Collmore?
Thank you, Madam Chair. Just curious, what does the phrase recently lapsed mean exactly?
It's 3 years. It's lapsed within 3 years in good standing. It's actually more clear than I said it in the bill or in the session law.
Yeah.
Thank you. Thanks.
So can we, Amarin, can you put this in an amendment for us and put it in the Jill's technical term, blah, blah, blah section?
Yeah,
Yes.
it's in there. It's in my written materials
Okay.
with the actual number.
Okay.
Sorry about that.
I prefer the tech talk.
It is a good one. Yeah.
Yeah.
I'm a pro. So,
I know.
Love it.
Okay, so we can put that in and everybody is okay with doing that. Okay, great. All right, let us move then to, I see Joshua Green is with us. So would you like to, thank you, Jill. Would you like to join us and tell us what the issue is here for you?
Yeah, I'd be honored. Thank you. Thank you so much. I appreciate the time. So for us, I'm primarily here to talk about 2 potential amendments that we are thankful that you're even hearing, and you can think about what you want to do after, obviously. One, to amend H280 to 1, change the ability of, in writing, for naturopathic physicians to sign birth and death certificates, and 2, to amend the use of the word physician in Vermont statutes. So basically, we're not asking for any change in scope of practice. There's this weird discrepancy where in our statute, it talks about birth and death certificates, but then in the language under birth certificates and death certificates, it doesn't list us. It doesn't specifically not list us, doesn't say naturopaths aren't included. It just says physicians and other folks, but doesn't list us. And, the issue is that it's antiquated language. At the time, no one thinks that it was meant to be exclusionary, but it is currently being interpreted as exclusionary from a very narrow legal viewpoint, which is, well, it doesn't list you, so you can't do it. Which, doesn't seem like a big deal, except that, so far this year, at least 4 patients have passed away who naturopaths have been their main doctor, either primary care doctor or main doctor, but not technically primary care. I think 3 of the 4 were primary care. And we were denied the ability to sign their death certificate, and it made the families really sad, as it should. And so we just want this to be fixed. And so we've talked to VDH, we've talked to OPR, and there doesn't really seem to be any resistance. Lauren, please jump in if I'm misspeaking. It's just that the language needs to change and to make it clear. So that's really, the crux of it. So there's some language change that we are putting in there. I can go into more detail if you guys and gals want, but basically, did we send you the my testimony yet?
I believe we have it.
Okay, I'll send it again just in case for all the details. So I'll quickly go into the details of what I was just saying. That was the overview. So the issue requires amendments in both Title 26, which is the licensing of naturopathic physicians, and Title 18. So we're proposing that this be added to H280. We've not had a problem, just for the record, with signing birth and death certificates up until like the last year or 2. So I'm not exactly sure why they're being interpreted differently by the powers that be, but they are. I'm not into blame or pointing fingers. I'm just saying this was never a problem. Previous folks in charge were like, well, yeah, it doesn't list you, but it was never meant to exclude you, so you're able to do this. And now we're presenting problems. And being the son of a lawyer, I get it when they're, when lawyers are like, well, this is what it says, and because it doesn't say this, there's different ways to interpret laws. So I respect the current interpretation. I'm just not happy with it, obviously. So we want to amend it. So provision in our licensing statutes, 26 VSA, squiggly 4124, sorry, I don't know what the squiggly means, presumes our ability to do so. It says naturopathic physicians are subject to the provisions of the law relating to contagious and infectious diseases and to the issuance of birth and death certificates. We've not heard any problems with NDs signing birth certificates, just to be clear, because most of these days, the NDs who are doing that are also ND midwives. So they wouldn't have an issue because their midwifery certification and license allows them to do that. But again, it's the birth and death. We can't just, have one without the other. And again, I mentioned the 4 instances where we were denied the right to do it directly from VDH itself. One of our members really kept on asking and involved a lawyer to have more questions, and it was certified no, not until the laws change. So that happened, and so the feedback we got from VDH was that 18 VSA squiggly 5202 chapter 107 sets forth the procedures for signing birth and death certificates for a licensed healthcare provider. The argument was that the definition of licensed healthcare provider in chapter 101 does not include NDs, so that's why we can't sign them under chapter 107. However, chapter 101's definition says that it's only for purposes of this part, not 107. So whether the definition only applies to 101 or it applies to chapter 107, we believe the statute should be amended to ensure that we can continue to sign birth and death certificates, because we are primary care physicians and it doesn't make any sense to me. And I'm hoping it doesn't make any sense to you guys. And I'm sorry to have to sit here and talk about this because it really should have never happened in the first place. So there's some title changes we put in for the birth and death certificates. For Title 26, we're offering changes similar to the writing in the osteopathic physicians licensing statute that would say reporting contagious and infectious diseases, death certificates, communicable diseases, and the granting of certificates of birth and death. Naturopathic physicians are subject to the provisions of the law relating to reporting of communicable diseases and to the issuance of birth and death certificates. And such reports and certificates shall be accepted by the office or department to whom the same are made or presented. We're just trying to clarify on all sides that we can, so this never happens again with a very narrow interpretation of the laws. Does that make sense to everyone?
Yep.
Not in any way trying to change our scope of practice. I really want to make that clear. Yeah.
Right. Yes. Senator Colmore, did you have a question? And then we'll hear from Lauren.
Yeah, but I'd like to yield to Senator Clarkson, who had her hand up first.
Oh, okay. Senator Clarkson. You're muted. You're muted.
Ugh, I'm trying to be so good and I fail at every turn. Anyway, Josh, it's lovely to have you. How many naturopaths are there? How many people do you represent in this association?
So right now, I think we have 55 active members, and there are probably somewhere between 65 and 80 naturopaths who practice in the state. I believe there are somewhere between around 370 licenses of naturopaths in Vermont, but I think only somewhere between 60 to 80 actually practice in the state.
Right. And you're licensed through OPR, it oversees your licensing.
Correct. Currently, we are we're under OPR. We do not have our own board, unfortunately, at this time.
Thank
Well,
you.
even if you had your own board, you'd be under OPR.
Yes, yeah, exactly, yeah. As opposed to VDH, I think. I'm trying to think who it is. Is it the MDs or the DOs who are under VDH? But yeah, we're under.
They
OPR.
are under the medical board.
Right,
Yeah.
which is why I asked.
So
Thank you. And then I have, once we're done with
Yes.
the serious part of
Yes,
the
Senator Clarkson. Yes, yeah, under OPR.
Great. Well, and then I reserve a question for later. Thank you.
okay. So Lauren.
So much. So Josh is right. The Title 18 currently does not include naturopathic physicians, allowing them to do death certificates. There have been birth certificates signed by naturopaths in the past, and it is because naturopaths have an endorsement called a childbirth endorsement, and they are basically equivalent to lay midwives attending home births. And we license the midwives as well. So the office has been contemplating moving the childbirth endorsement that currently is available on naturopaths to the midwife section requiring dual licenses there, because it is, the law in midwifery is clearer on what's required for a home birth than it is within the naturopath chapter. And so the Department of Health has been allowing birth certificates to be signed by naturopaths. In this narrow window, I think there are 3 naturopaths in the state who have the childbirth endorsement currently. Death certificates, it's my information that death certificates have never been allowed to be signed by naturopaths in the state. And I think you obviously will need to hear from Mr. Englander. He's more of an expert on the Department of Health than I am, obviously. And the reason is that Title 18, Section 5202A states that, I'm sorry, I got the wrong section. It is Title 18, Section 4999. States that for the purposes of vital records, a licensed healthcare professional means a physician assistant, or an advanced practice nurse. And it's really important that the word physician remain to be defined as allopathic or osteopathic. That is the traditional definition of a physician. The word physician is put through all of Vermont state statutes. It cannot be modified to include naturopathic physician. If the committee wanted to make an adjustment to the title for the purposes of death certificates, I would recommend that you put the full term, which is what naturopaths are allowed to call themselves. They're allowed to call themselves under our titles in Title 26. They're allowed to call themselves a naturopathic physician, but they are not allowed to call themselves a physician without the modifier. And if we start to expand the definition of physician, it would require a large scrub and evaluation by the legislature of the entire statutory construct, because physician is used to mean allopathic or osteopathic. It is, and not to include chiropractic physician and naturopathic physician. So I would really caution the committee to be careful with modifying the term physician in any place in the statutes. And then with regard to death certificates, I haven't had an opportunity to look into whether or not this is a scope expansion. I don't know what the training is of naturopathic physicians to assess the cause of death. That's a piece that I'm not clear on. I don't know what the training is, but when you sign a death certificate, you are certifying to the state what the cause of death is. And if the cause of death is undetermined or unclear, then an autopsy is required to be conducted. So it's my understanding that the Department of Health has an interest in having folks who are appropriately trained to assess the cause of death, who are sometimes the observers of the death, to be the ones who sign the death certificates. Now, certainly the signers of death certificates would reach out to naturopathic physicians to get copies, if they're the primary care provider, to get copies of their records to understand their underlying health conditions. I think that happens on a regular basis. But to be able to determine the cause of death does require some level of expertise. And I have not had the opportunity to look into whether or not naturopaths are qualified to do that.
So I have a couple things here, and then I think that we could, if the issue is whether they've had training or not. When my mother died, the hospice nurse was the one that signed off. I'm pretty sure. No?
I don't think the statute allows that.
Okay, well, there wasn't a doctor there, so they must have called a doctor then and said, but the doctor wasn't there at all, didn't have any idea why my mother died. I mean, I guess the question I would have is, if if we don't think that naturopaths are qualified to determine cause of death, I mean, I guess that's the crux of the question, right? Are they qualified to determine cause of death? Because if they are, then they ought to be allowed to sign the death certificate.
I agree with you. If they are and the legislature would like to do that and the Department of Health supports it, then absolutely. But I don't know what training they receive on this, and it may be that it exists and I'm not aware of it. I just can't provide a recommendation to you on whether or not they're qualified at this time. And I think the hospice example is a really interesting one because a lot of scenarios, a nurse is identifying that someone has died, and declaring that someone has died in a clinical sense, but the actual signing of the death certificate has to be done by these three groups of people: the physician, the physician assistant, or the APRN. And I think it's because of their clinical training in hospitals, et cetera. I think that they're trained on how to do this. But again, I don't know, this isn't my area of expertise, and I don't know the training of naturopathic physicians on this particular area.
So I guess what we do need to find out is if naturopaths are trained in determining cause of death. Because if they are, then there's no reason to not let them sign the death certificate. And we could do it without changing the definition of physician. We could just add naturopathic physician. But so Josh, can you enlighten us here?
Yeah, absolutely. So I can't think of any way, shape, or form that we're not trained to determine cause of death. If there's any question, then you can always have that looked into by someone else who has a specialty in, particular rare forms of death. But I think for a primary care physician, we have all the knowledge that a primary care physician needs to diagnose cause of death. And if there's ever any issues that come up, then the appropriate bodies will be contacted to look into what might not be obvious to the primary care physician. So I don't know of, I'm not exactly sure what kind of information, Lauren, you want, but I think we are absolutely trained to determine cause of death for everything that a primary care physician should be able to know. And in regards to your other question, I want to be clear. We are naturopathic physicians. We are not allopathic physicians or osteopathic physicians, and absolutely not asking for any change in the definition of the word physician. That would be a legislative nightmare for everyone involved. But what we do want, and I'm sorry if it wasn't clear, what we do want is something that we asked for, I think 9 years ago or so, which is legislative language to request a legislative council to prepare a catalog of the use of the word physician or doctor, so that other issues like this don't come up for practicing naturopaths while we're trying to be primary care physicians in a state, but all of these challenges come up.
Okay, so that's a different question. And we can address both of them, but the first question that we're going to address is that death certificate, because the other one is a much, much bigger ask. So I saw Senator Colomer had a question, and then Senator Rahm.
Thank you, Madam Chair. Yeah, so when Mr. Green was testifying at first, and this is just for clarity, I thought I heard him say that in the past, you have been able to sign both birth and death certificates, and then there was a change in the interpretation somehow, and yet the Department of Health and OPR was not against this. So I was trying to figure out who was against it then. Does that make any sense?
I think it's the new Department of Health, is what I understood.
I had a similar clarifying question of just, have you, ever signed a death certificate before and all of a sudden you can't? I didn't get the sense that you had signed them in the past.
Yeah, so to my knowledge, the naturopaths, before I arrived in the state, I think it was like 2011, had, and I think a few years later, I think this was like Harry Chen's time and possibly prior to Harry Chen. It was my, I was informed by the naturopaths who were here at that time that they were able to do so without any issue. And if I'm wrong on that, I will get back to you and I apologize, but I'm very certain that that's what they told me. And that now that Harry Chen has passed the torch on, the interpretation is different. And there's this, well, it says in your licensing statute that you can, but it doesn't say in the actual statutes for birth and death certificates, so you can't. I find it interesting that we are, that it's, you know, Lauren, that you're saying that we're able to do birth certificates, but, you know, I'm not a licensed midwife and a naturopath. I'm not a naturopathic midwife. So, I mean, I'm not doing birth certificates. So, you know, it's like I said, it's only the naturopaths who are licensed as midwives and as naturopaths. That's a totally separate license or certificate addition to it, and that's clearly stated that they can. So what I was saying is that naturopaths who aren't licensed midwives can't write birth certificates to our knowledge based on the current interpretation of the law. But, you know, but I don't know if they were able to before. Very few naturopaths do births if they're not naturopathic midwives. And I want to be clear, like, I'm not blaming anyone. Like, you know, the current OPR under Lauren, like, I really appreciate everything that you do. And same thing with Dr. Mark Levine. We really enjoy working with him. He's doing a great job. We're big fans. It's just that this, you know, this issue is an issue for us. And that's why I'm here today.
So I think what we need to do is we need to find out first what kinds of training that an MD might have to determine cause of death is different than what an ND might have, because an MD isn't a specialist. I also wonder why a naturopath who can't sign a birth certificate if they're not also a midwife, because an MD can sign a birth certificate. And MDs, both of my children were delivered by MDs, not an OBGYN, but an MD. And if an ND has hospital privileges, why couldn't they sign a birth certificate? So I think that we need to find out why the difference here. Does anybody else have any questions? I think that we need to hear from David, but we also need to hear, well, I was going to say from the medical society, but no, I don't think we do, because they will oppose it, I think.
Well, Senator White, I do think that they would have a perspective on what the training is around this issue, and I think you should hear more from Josh too about what the training is on this issue.
Yeah.
It's not. I don't think that there's. I think that that's a verifiable fact what the training is, and I would appreciate if you would hear from David Englander from the Department of Health, because it's certainly, you know, I don't want to be the arbiter of Title 18's statutes. All I can say is that we were asked to assist with the interpretation. I agree with the interpretation of the Department of Health. I do think that it's very important to be careful about assuming that people who provide care are by default able to do everything that a primary care physician does. I think that is worthy of exploration if we're talking about modifying statutes.
Mm-hmm.
And so I'm asking that the committee do that exploration and maintain the integrity of the definition of physician in statute and the definition of naturopathic physician, which it seems like we're in consensus with, but that's what I'm most cautious about.
Yeah, I'm not so sure that I want to go right now to changing the definition. But I think we can solve this issue of birth and death certificates. Senator Clarkson.
So you and I both had mothers, Madam Chair, who died in hospice, and my mom just died in November. So I have her death certificate, and actually it is signed by the overseeing physician. Even though the hospice nurse said, I'll take care of it, I just assumed she had signed it. But no, it is the final, in the final analysis, it is the physician who was overseeing her case. So even with hospice, it is with a physician who signs the death certificate in Vermont.
Senator Clark, Ram.
I just have one more question for Dr. Green. Did you sign death certificates in the state you had come from?
No. Is everyone there?
Yeah.
Oh, sorry. I thought you guys froze. No, I was actually practicing in New York State prior to moving here, where we can't even order labs. They are so far behind medically. It's really bad. So no, and I did not. That's one of the reasons I moved here, was that I didn't like being a non-PCP. I didn't like just treating people who had money and having them cross the border and do labs in Pennsylvania. It just didn't seem right to me. So I moved here so that I could practice primary care and help patients who are on Medicaid, and as well as I have some rich patients, but the majority are not. And I like to work with them all.
And can I ask one more question? So when someone dies who's under your care, what do you do now?
That's a good question. To my knowledge, have not had that happen yet. Part of the reason for that is, as a naturopathic physician, we can't get reimbursed by Medicare because it's a federal insurance. And so most of my patients who get to Medicare status then have a different primary care physician, and then I become a specialist if they want to continue working with me. And so then their primary care would then sign that death certificate, because I would no longer be their primary care. So I haven't had, fortunately or unfortunately, I have not had any patients pass on under my care yet.
Okay, so unless we have more questions right now, what I'm going to suggest is that we find out more information about specific training around birth and death, the causes of death, by the naturopathic community and the MD community, to see if the training is the same or is at least equivalent. Does that make sense?
Yeah.
Senator Clarkson?
Yes, I'd just like to tag on to Senator Rahm's question, which is I'd like to know which states do allow this, because it would be very interesting to find out how many states are a little more ahead of New York, but maybe just behind us. So it would be great to see who else is allowing this.
Yeah,
That's a great question. I will get that information to you. That's way easier and quicker to get than the training information that Lauren's requesting, but I'm also happy to get that. That's just going to take a little bit longer.
okay. Well, we have some time.
And an informal aside, Madam Chair, we're all curious, but now I know you're New York Stater, so cheesecake makes some sense, but your strawberry cheesecake, you need to know what the origin of this moniker is.
Oh, I'm excited to tell you. So I was on a car ride with my sister, and we're driving from, she was in school in New York City, back to Michigan, where I grew up. And so to keep me busy, she said, if you could be any kind of dessert, what kind of dessert would you be? And I was driving, and all I heard was dessert, and I love strawberry cheesecake. So I said strawberry cheesecake, and she patted me on the shoulder and she goes, "Oh, of course you'd be a strawberry cheesecake cutie."
Got it. Because we had lots of questions about who you were when you were trying to get in.
Oh, yes, of course.
Okay, so we will, we had potentially this on for Thursday, but I don't think we'll have the information that we need to make a decision on this by then. But we could still take up the OPR bill on Thursday, but without this necessarily. We'll look at the MMA language and the amendment that Jill had, and then anything that comes out of the discussion now about the criminal background. Does that make sense? And then we'll schedule it for the next week.
Yes.
Okay. Right. Okay. Everybody seems okay with that. Okay. Thank you. Thank you, Dr. Green.
Thank you very much. It's been a pleasure and honor. Appreciate it.
Thank you. So do we want to jump to Michelle and Josh? Oh, there you are, Michelle.
Thank you for having us back. We appreciate it. And I'm happy to just, we had a great meeting. So again, for the committee, I'm Michelle Feldman from the Council for State Governments, and Joshua Gaines is my colleague. And we last time were talking about best practices for people with criminal convictions to have access to professional licensing, because people with convictions are recognized as one of the groups, in addition to military spouses and some others, that face a lot of barriers to get a professional license. So this is kind of a national initiative that we're working on at Council for State Governments to assist states with implementing best practices to address these barriers. And so after the meeting that we had in the committee, we had a great conversation with Lauren and Beth from OPR, and I just want to thank them they really understand this issue in a way that most, licensing agencies in states don't, because they have criminal justice backgrounds. So
but that's because they don't have Lauren and Beth, who I've never met before, but they don't have such a great, we have the best OPR office in the country.
Yeah, no, it's really impressive. I mean, I think most agencies, they don't understand the criminal record aspect, and thankfully Lauren and Beth got it right away. And based on our conversation, it sounds like OPR is doing a lot of the best practices, but it's just not codified. So that's kind of what we focused on, what can be codified that OPR is doing in practice already, because OPR it doesn't cover every license occupation in the state. So how do we, put it in the statute to achieve uniformity across licensing, and also to ensure that when there's a new administration and new personnel, these best practices are maintained. So really the big takeaway that we had from the conversation was to codify the specific factors that licensing entities have to consider when they're considering a criminal record. So the point is really to ensure that the licensing agencies are assessing the person as a whole. They're not just seeing a record and making a judgment, but they're considering specific factors like what is the direct relationship between the crime and the occupation. How long ago did the crime occur? What is the evidence that the person is rehabilitated? What age was the person when they committed the crime? So looking kind of at all of these factors that can tell the whole story about the individual, rather than just having a written record about a criminal history. And so I think that Lauren shared in her testimony some language that seems acceptable for the statute, and we really applaud as in line with best practices for ensuring these individualized assessments of criminal records. It would just make a big difference in fair licensing, and that is really would bring Vermont in line with a number of other states that have similar statutes that really outline the specific factors that have to be considered with a criminal record, by licensing agencies. And Josh is really the expert on all the specifics. So I will let him, if you have anything, Josh, that you want to add or.
Can I jump first? I saw Senator Collmore had a question.
Thank you, Madam Chair. So last year we passed, and I think it was in the OPR bill, that sort of expansion of the ability for someone who had had a conviction to apply for a job. I guess I'm not clear how much this changes that. I thought what we did last year made a lot of sense, but I'm not getting the idea about what does this do to what we did last year, I guess. And it's more a question for Lauren. So if you want to wait, that's okay too.
No, unless Josh has something to add, and then we'll jump to that question.
No, I'd certainly defer to Lauren. I would just say the previous bill for the pre-qualification applies, to a very specific process, and this is more about creating standards that are generally applicable to criminal history decisions.
So Lauren, do you want to?
Sure, I'm happy to. So the bill that you passed was, it's in S-233, which was the broad licensure reform that touched on all licensing entities in the state. And the section on criminal backgrounds was second chance determinations, which allowed somebody who has a criminal background ask for a predetermination on whether or not their specific crime would preclude them from a specific profession. And it's a process that is outside of the application process itself. It's really intended so that someone can get a quick analysis of whether or not their crime will preclude them, maybe before they get education or training, certainly before they submit the full application, go through the work of the full application, which can be expensive. Some of our applications are multitudes of $100. So not all of them, some of them are, $25. So we have a spectrum, and maybe you wouldn't want to submit a full application if your crime was going to preclude you. So the predetermination process, we're now 6 days into it. It was effective on April 1st. So I intended, and I forgot to check how many people have gone through the process in our 6 days. I don't think very many. Maybe Beth knows. She would review them if they came through. So Beth, have you seen any?
I haven't. Beth St. James, I'm the chief prosecutor for the Office of Professional Regulation. We haven't, but they won't all cross my desk if it's a no-brainer. But we have not seen any yet.
And remember, April 1st was Thursday, and then we had a weekend.
Right. So we've only had 2 business days, really. So that piece is something I'm very proud of, and I think this committee should be very proud of that work. What CSG is recommending is something slightly different. It's codifying in the statute, and what I'm recommending for language mimics the language in S-233, but it's codifying in language what would be the cause for a denial of an application even outside of the predetermination process. So if you didn't go through the predetermination process and just submitted an application, what the office is going to be looking at. And I really see this as a 2-pronged strategy. One, codification of our current policy, which I tried to outline in my written testimony, and I'm happy to walk through. And 2, I think we need to do a better job of making this clear on our website. And that's always true for OPR. We're always trying to make things more clear to the public on our website. And this is an area where we need to do better. So we don't have a written policy of how we've treated criminal backgrounds in the application process. Beth St. James has worked for the office for 6 years. She does an excellent job reviewing applications. And she really has a firm policy of how she reviews applications, one that I completely support and is put into my written testimony. We do look at misdemeanors if they're related to the practice of the profession, and we look at felonies, and then we do an analysis of how closely any of these crimes are related to the practice of the profession, how long ago the crime occurred, and any evidence of rehabilitation. So I do recommend that you put that into the statute, that policy into the statute. The recommended language is on the third page of my written testimony. It would be in addition to 3 VSA 129A, which is where we had our written policy around this before. Our written policy around preliminary denials came out of 3 VSA 129 AA 10. And it just said conviction of a crime related to the practice of the profession or conviction of a felony, whether or not it's related to the practice of the profession. And I recommend that you add a subsection saying that if the individual has a conviction of concern, the board or hearing officer shall consider the following in determining whether to deny or discipline a license, certification, or registration for the individual based on the following factors: the nature and seriousness of the conviction, the amount of time since the commission of the crime, the relationship of the crime to the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the profession, and evidence of rehabilitation or treatment. That is what we do. That's the analysis that we do. And I think that it would be appropriate to put it into statute. Again, unlike S233, this only affects OPR. I think there's likely more work to do for the other licensing entities. This is not a universal licensure reform bill. This is a recommendation just for the OPR umbrella. But we do regulate, and the House is at this moment debating home contractors. So we may regulate after this session 51 professions. So we do regulate quite a few folks, and this would have a broad application. And I think it would be helpful if you were looking at the statutes, what will happen to me? This would provide some answers. And I think that's really what CSG is asking states to do, is to provide answers to somebody who doesn't know who Beth St. James is, doesn't know who I am, and doesn't have any idea of the next person who's in my seat. Nobody knows who the next person who will be in my seat is, but it just provides clarity and transparency on the process and what's happening. Another substantial recommendation from CSG was to make sure that written notice was given to folks before a license was denied. We are doing that. I provided an example of that work to this committee. I don't think that statutory change is required there. I do think that that's an area that we could make more clear on our website.
So go ahead, Josh.
Oh no, I just wanted to say this is, and that final point that Lauren made is something that we discussed, and I may have implied mistakenly that does not exist. The process is statutory, where you get an initial denial, and that then you have a chance to respond before you get a final denial. The distinction is that in Vermont, there's that process is not specific to criminal history determinations, and as such, it doesn't include all of the language and standards information about criminal history determination. But it sounds from our conversation like that process is working out.
I think that this, I also serve on judiciary, and I think this goes along with what judiciary has been doing around expungement of records and the probation, trying to relook at how we do probation and conditions and everything. So I think that this fits very nicely into, in fact, that's where this came from, because Josh was in judiciary and was saying all these horrible things about Vermont. And I said, no, you can't be right. So anyway, and he was half right. So Senator Clarkson?
We have in other areas in the state, I believe we have this ability to, we license people who have criminal backgrounds. Our lawyers, our bar licenses people with that have had criminal backgrounds, felons, and we have licensed lawyers in the state who have felonies. So we have been doing this actually in other areas for quite a long time, and it's particularly interesting that the legal profession did this many years ago. So
I agree that the bar does license people with criminal backgrounds. I'm not clear that the statutory language is clear on that, Senator Clarkson. And I think that's the difference of what CSG is asking is policy is one thing. I'm confident that the Department of Health licenses people with criminal backgrounds for the medical practice board, that teachers with criminal backgrounds are licensed. And until recently, DPS didn't even ask if there was any criminal history for plumbers and electricians. So I think the balance, and it's a big political discussion and a policy decision ultimately for you, is that balancing act of what do we require people to disclose when, and then what do agencies do with it?
Yeah. I was just trying to underscore that this is not so unusual. I mean, we're already doing this in other professions, you know, around the state. So.
No, I think in testimony for S233, I think I said multiple times, at least multiple times in your committee, that I'm very proud that we license people with criminal backgrounds. I think it's a really important thing to do. And I think providing some process around it is helpful for someone who is external to the state or to certainly to the Office of Professional Regulation.
I saw somebody's hand go up, but, oh, there it is. Okay, Josh.
I just wanted to say briefly, piggybacking on that conversation, that you know, one of the big issues as, you know, these barriers, you know, across the country, in Vermont, elsewhere, to all sorts of opportunities, employment licenses, you know, housing, all kinds of things, have become more common, and more people have criminal convictions now than ever before. It's not just what's going on, right? We heard from Lauren and Beth that denials based on criminal history are pretty rare, and that's consistent with what we hear across the country. But that stigma that if you have a criminal conviction, you are not able to get licensure, you can't get, you know, you can't move forward in these areas and into higher, you know, level career paths, is a real thing. And to the extent that states can clarify in their code, in their practices, and the information that's being conveyed, that these opportunities are available, and not just that they're available, this is how you can begin to think about navigating them. Because it's, you know, it's a scary and complicated process for people who've never dealt with it. So it's not just the policy, it's not just the decisions that are being made, but it's about opening that door and providing some sort of signposting for people to get through it.
Any other questions or comments, concerns?
Yes.
Senator Polina?
But just two things for Lauren. Lauren, I think what I'm hearing you saying is this is codifying what you already do in practice, correct?
Yes.
Yeah.
Yes.
And not that this is a bad thing, but it is kind of subjective in a way, you know, the nature and seriousness of the conviction. I mean, some people may say, oh, whatever that person did was really serious. Another person might say, well, that was not so serious. So there is, I'm not saying that's a bad thing. I'm just confirming that it's sort of subjective at some level. Is that true?
Yes, it is. It absolutely is. And I would say that it's subjective, but it's backed up with due process. So, right. So the person is able to provide mitigating information about the conviction. Beth and her team assess it and then have to write a preliminary denial notice that clearly articulates the nexus between the crime and the profession. My very crude example yesterday is you can be a murderer and be an accountant, but you can't be a murderer and be a cosmetologist, or you can be an someone with a fraud and be a cosmetologist, but not an accountant, right? Like the crime has to be related to the practice of the profession. Of course, that's a very crude analysis, but the crime has to be related. And Beth's team has to articulate that and put that into writing. And then a hearing is scheduled. Well, a notice is sent and the person has 30 days to respond to the notice. And then if they respond, appealing the preliminary denial, then a hearing is scheduled. They can hire an attorney or appear pro se. Most appear pro se. We have a fairly open process for pro se litigants. And a hearing is held either before the board or an administrative law officer who we hire. and then a decision is rendered, a written decision. And then as soon as that written decision is rendered, then appeal rights attach, and they can appeal. We have an appellate process in-house. So the first level of appeal is within OPR, and then the second level of appeal is at the Supreme Court. So it's not just Beth's discretion that makes this determination. It then is heard in front of a board or hearing officer, and then it can be heard in front of an appellate officer, and then it can be heard by the Supreme Court. So almost all decisions are somewhat discretionary, but I think the due process is the piece that is protective of the applicant. And I would caution and strongly recommend that you not provide a list of excluded crimes. And the reason is Vermont's criminal code is not the same as New York's criminal code, is not the same as Arizona's. And our even the types of crimes can be different, whether they're felonies or misdemeanors in different jurisdictions. I think that it's important to have that flexibility and that discretion really baked in, and trust the due process that happens on the back end.
Thanks.
Other questions, concerns? No? So can we, Amron, can we get this language also? And maybe on Thursday, we can go through everything with the OPR bill, with the exception of the naturopaths, because we won't have time to get all that information before then. And then we'll schedule that for the next week. Does that make sense?
Yes.
Yes.
Lauren, do you think you'll be able by then to have some conversation about the fees?
Yes.
Okay.
It is my understanding that that conversation has started on some other topics related to MMA, but fees have not been discussed yet. But I can make sure that that conversation happens by Thursday.
Okay. All right. Okay. So if Senator Collmore.
Yes, thank you, Madam Chair. I just want to let you know, I remain unconvinced 100% that we need to do the thing that we've been talking about today, but I am going to read Lauren's testimony as well as Michelle's. I still am not clear, I guess, if something is only 6 days old, why we need to change anything more until we know whether or not that's working. Is that fair?
Yeah, maybe I can answer that in referring a little bit to judiciary. What we're doing with what we did last year is just letting someone know before they go through the process if they might be denied or not. But it doesn't set any better standards for, it still leaves all the standards for doing that subjective. And that's my understanding. And in Lauren's case and Beth's case, I believe that they have it nailed. But we don't know who's going to be in that position in the future. And that whoever is in those positions in the future might say, we're just not going to give anybody a license if they've ever committed a felony. That we're just not going to do it, period. And because there's no statutory language around what they need to consider and how they need to consider it. And I think that's the fear, is that so they could still do this letter ahead of time, which is what we passed last year, and say, yeah, we're not going to give you a license. So don't go through the process at all. And that would be fulfilling the requirement that we passed last year. But it wouldn't codify at all the standards and how they're to be applied to people. And I think that's the issue, is that it is so subjective that if somebody gets in there and says, we do not want anybody with any felony or even a misdemeanor to be given a license in the state of Vermont. That could happen unless we have some statutory guidance. That's the way I see it. I'm not sure if I said that right or not, but
Yeah, I think that you said it perfectly. I mean, they both have, there's a big deterrent effect for people with criminal records. You know, so the bill last year addresses it before the person goes through the application process and has to spend all the money and time getting trained in something. They, can submit an application. The board would see, oh, you have this conviction, but they don't have any kind of guidance on how to assess the conviction. So the risk there is that somebody in a licensing agency just sees that conviction and says, no, like don't go through the training, don't pursue this because, you have this conviction. And what this bill does is it creates standards for the licensing boards of, factors that relate to public safety and how the individual has rehabilitated since the conviction, so they can kind of tell their whole story before they just get rejected. So I think it builds on what was done last year, and it addresses like two different parts of the process. The bill last year was, before somebody applies, getting an assessment, and this part is after somebody applies. They will know even before they apply, these are the factors that the boards are going to consider. This is how I'm going to explain my conviction and make my case for why, I shouldn't be denied.
Okay, I appreciate that. Thank you.
Any more questions or comments, concerns? Okay. Thank you. Thank you.
So much.
Thanks.
Thank you for the time.
So I think Gail and I got our wires a little crossed. Who's Lauren Glad Daviton?
Oh, she's Mark's wife. She's the Center for Media and Democracy. She was with Common Good Vermont, and she's now she's there with the TV. There she is with her fabulous self. There she is. Hi,
Yeah.
Laura.
So I think we got our wires a little crossed. So it seems that S106 is on our list for today.
Oh,
But-
it is?
Well, I was just looking at the agenda and yes, it is. And I
It
thought I
is.
had taken that off. But
I thought moved. I remember that discussion. Oh, well, we have Lauren
But-
now.
so I think I should explain what we're doing with 106 because I don't know what your testimony was going to be at all, but let me explain what I think we're doing with it. First of all, there are two parts to it. One is the making sure that we learn from what we've gone through in terms of public access and participation. And then the second is the issue of lobbyists wearing name tags. And I think we're not going to address that part of it at all. And we are still, S106 is the way it's worded is that it would set up a pilot program, but that language was from a number of years ago. I think Amron said it was the same language that was introduced in 2014 and 2017. It was
similar language.
So we have now had our pilot project, all of last year and all of this year. So we don't need a pilot anymore. What we need now is a committee of legislators to work with the interested groups out there to come up with the best way of continuing the kind of access that we've been having in the last year and a half or last year. And so what we're still trying to figure out is if we need to have legislation or if we just by rule, if it's just a legislative committee, we might not need legislation. We might just need to go through the rules committee and have the rules committee set up a group of legislators to work over the summer with the sergeant at arms and the secretary's office and the clerk's office and media groups and public interest, good government groups and all of that. So does that make any sense to anybody, what I just said?
Yes,
Senator Clarkson?
it reflects our conversation very well. The other key piece is the money. So it's going to be an expensive transition. And so we also need to be weighing the cost of it from the state, which is quite different than where we are here on a platform that we pay for, but recreating that platform within the context of a physical committee is I think the additional challenge. So it'll be legislators, media groups, but also the nuts and bolts of how we finance it. And if we roll it out, how we roll it out, if we do, it's a whole schmagegi.
Right. But it will be a legislative committee that looks at all of these things and uses the expertise of the sergeant at arms and the secretary's office and the clerk's office and our IT people and now who's Kevin Christopher?
So Kevin and I were slated to testify today, and I asked him to hop on now. I came early because I know sometimes you finish what you're doing early. So he is my colleague from Lake Champlain Access TV.
Okay.
And we prepared testimony. It's very brief and it speaks to your point.
Okay.
So, he should be here any second.
I think he was trying to get in, so I think Peggy is letting him in.
There you go. There he is.
Okay. Thanks.
Yeah. So Kevin, Senator White just did an overview of what we know, which is that there is an intention to have a study committee on this question. I might just take slight issue with one thing that you said, Senator White, and that is you have done a pilot in the virtual space, but you haven't yet done a pilot in the hybrid space, which is to have people in a committee room physically and to have people virtually. And one of the reasons that Kevin's leading this testimony is because the Access leaders have developed a real expertise in these hybrid meetings. And so we had a series of questions to pose to you that may become part of maybe the mission of this committee, or questions we think would be valuable to consider within the scope of the committee. So that was really what we wanted to bring to you today. And Kevin is in a very good position to do it because he's actively involved in putting those hybrid meetings together and providing technical assistance for the folks in his community, much like the 25 Access centers, community media centers across the state.
Great. Thank you. Thank you. Kevin?
Sure. Well, thank you for your time today and for including us in your committee meeting. Just looking at our experience and what we do in terms of live streaming and understanding that what we've done in the past year is almost 100% in that realm. We did come up with a list of questions and considerations as you go forward into potentially a summer study. And just to bring up some of those now for discussion, is the purpose of live streaming to provide, as you do now through YouTube, a one-way communication to the public of your goings on in the State House? Or is it to do more, as Lauren Glenn was saying, of a hybrid situation where there is the opportunity for testimony for more of a two-way interaction once you get back in person in the State House with people who are outside of that realm? Looking at some of the nuts and bolts in terms of the technical considerations, the equipment, the platforms, what the costs involved there are in terms of both operating and capital, and policy considerations, including but not limited to media management. Where do files live? How are files moved around? How is an archive built and maintained? Who is overseeing that on your staff? What is the policy involving getting rid of files over time if storage is an issue? And all the costs there. There are so many, a myriad of options in terms of data storage and file archiving that can run the gamut in terms of cost. And how does this fit into any ongoing or planned IT upgrades within the State House, audio upgrades within the State House? And something that we've talked a lot about internally in the Vermont Access Network is this part of a larger discussion in terms of creating something to take the place of the now defunct Vermont Interactive Television, that kind of statewide public meeting network that we no longer really have in Vermont. So those are the kind of the thumbnails of what we have discussed, and really what we deal with in our community media centers day to day in terms of streaming, archiving, and planning our live and hybrid meeting coverage.
Yeah, I think all those questions will have to be asked, and I didn't mean to imply that we didn't need to have a pilot, but and we might, I don't know how it's going to shake out. If it's going to shake out that we try it with one committee in the House and one committee in the Senate and try it that way, or if I don't know. I think those are questions that we have to ask, and that the group will have to tap into the expertise, including you guys, for the questions to ask and how to go forward. So, Senator Clarkson?
Yeah, and I think your question, Kevin, is a good one about the one-way or interactive, because it could be very disruptive to have it be two-way. On the other hand, any system we build, we'd be crazy to not make it flexible or have an ability for it to grow. So we might begin with it one way, which it is now. So we only admit the witnesses we've asked, or who have come or who've asked to testify ahead of time. And the rest of our participants are it's one way. They're just watching our committee deliberations. But I would hope anything we did could evolve if we wanted to trust it to become a two-way system, and we could actually afford to manage it, because that requires more management. So I would hope whatever we decided over with this task force, that it would be a system that could be built upon.
Yeah, and I don't think there's anything. I don't think it's either one way or two way. I think that there will always be a part of it that's just one way. As I look at this, I mean, I don't think we want to have 260,000 people, 620,000 people being able to weigh in at any time. So there are parts of it that, when I look at it, will always be one way, and there are parts of it that will always be two way. But I don't think it's either or.
Well, but for example, I think, just thinking out loud and thinking about this, because I think this will be an exciting task force actually to serve on. One of the questions is, could this same system then be used for our public hearings, where we may want to have 200 or 300 people in a room and able, in a controlled situation, to ask questions in a substantive way, and have, be able to have it be two-way with a larger group. So
yeah, I think it depends on,
because Becky can tell us now in real time how many people are on YouTube watching this. And yet we only have however many we have here, 8 of us or 9 of us are actively able to interact. There may be 200 people on YouTube watching this meeting.
But so there's a difference. There's committee meetings, there's floor sessions, and there's public hearings. There's many different layers of and they are, my guess is they will all be treated slightly differently, that they won't all have the same rules in the same format. But that's, Lauren, did you have your?
I was going to echo what you just said, which is really, when you start to open this box and look at it, you're moving from the committee room to locations across the state, really, when you talk about public hearings. And so what is the legislative space, and how do you make it available to people, given what we've learned, which I think, your point about the last year, we've learned quite a bit. So those findings certainly can be brought to the table. And I would just say, just one final comment I have is that Vermont Access Network is at your disposal. We are happy to participate in that study committee. It would actually be helpful for us to do so, given our involvement in public meetings. And we support this effort.
Right. And you have been the most you have been filming us for the last several years in committees on and off, the mostly the Montpelier, but they then feed into the Vermont Access Network. So it's yeah, you've been very present all along.
Yep. Senator Colomar.
Thank you, Madam Chair. So yeah, your point's well taken. I think if this sort of two-way street goes too far along, what's the point of having a state house? I mean, we don't need to have a state house anymore. We could just do everything from home and have committee meetings at wherever we wanted to, and people could testify. So I'm fine, I guess, with what we had to do over the last 12 or 13 months. But I don't necessarily think that that means that we need to explore even further ways to change the way we do business. I very much value the committee procedure that we have now. If people feel strongly enough about an issue, then they're going to have to drive up to attend a session in person. That's my view anyway. And the floor sessions we've already, for many years, made available for people to listen to, at least on the public radio situation. So I think it's okay to study it, but I wouldn't jump both feet in to completely redo what we do.
Well,
Yeah, if I can, and Peggy, you can let Amy in. I think that that we have to be aware of the expectation that we've built up, that people have the ability to watch, and that's okay. But we also have to be aware of the cost of anything we do. And I'll tell you, if we had, right now, anybody can see all 5 of the committee members, right? If we were in the State House, we would have to have 6 different cameras in each room in order to do that. So I think there's going to be a compromise.
Yeah.
It's not going to be like this, where everybody can see us, each of us, all the time, because we simply, I don't believe, can afford to have 14, no, we have 11, 14, we have 25 committee rooms. That's a lot of cameras, and that's a lot of somebody working those cameras and keeping track of it behind the scenes. And I agree with you, Brian, that there's a compromise. We've always let people testify on the phone if they needed to.
Yeah.
And we could make accommodations so that somebody could testify like this if they needed to.
We have that ability in most of the House committee rooms, and in by sort of portable method in most Senate committee rooms. So we already have that ability. It's just clunky in the Senate, but easier in the House. The House has whiteboards where they can do that now.
You mean let somebody testify visually?
Yep, up on the big screen. Yeah, many of the House committee rooms have that ability, if not all.
So, I mean, that's something that we can do, but I agree with you that our committees are going to be held in our committee rooms. That's my personal feeling, that is where the committee operates out of.
But
and how
I think you're also right, and we can't put the genie back in the bottle. I think that we've now created an expectation of openness that is just, I think, kind of exciting, that so many people can watch and participate and respond then in real time to what we're doing. So I think it's going to be hard to put that genie back in the bottle.
But watching is different than participating in real time.
Yeah.
And I think that we really need to be careful about opening the the expectation that just because you're watching, you have the ability to participate.
I think Lauren had a.
Yeah, Lauren.
Thank you, Madam Chair. One of the really exciting things I think Kevin could also say something about is that the equipment has become much less obtrusive. So in prior times when we've had this conversation about bringing cameras into the committee rooms, we've imagined having a person and a camera and a tripod, and especially in those house rooms, it's very difficult. But now
Jeanette and I deal with it all the time.
Yeah.
Right between us.
So, but now we're talking about very small cameras and microphones that sit in the middle of the table. And so the equipment can be much less obtrusive, just so you know. So I think that also changes the nature of the discussion and what's possible. Right, Kevin, when you.
Yeah, and I think that's where we and Van come in handy, is that we can point you to what we're doing so that instead of 3 cameras around the conference room, you have 1 camera that is capturing the entire committee and that doesn't have a camera operator, that is cost effective, that is space effective, and accomplishes what you need it to do.
Yeah, I mean, I know that the equipment has changed a lot, and that is why whatever this committee is that gets set up for this summer needs to be able to tap into your resources and into our own IT. I mean, we have our IT people who are very, very helpful, but we need to know what their capability is and how much it's going to impact their jobs and our committee assistants. What does it mean for them if they're balancing all these things? Do we have to have 2 committee assistants? Or I think that there are a ton of questions that we need to ask. And Secretary Bloomer, when he first read about this bill, said, I have a list of about 100 questions that you need to ask before you can even think about where you're going with this. So, I mean, there's a lot of people out there who have a lot of input, and our sergeant at arms and our Capitol Police.
Right. And they'll all be on the task force.
No, I think it has to be a legislative task force, and using the expertise of other people. Otherwise, you're going to get a huge task force. But that's just my personal opinion. Yeah.
When appropriate, might we have a break? When it's
yeah. Well, I think that
a break on our radar screen.
I think that this. See, I think
this is the last thing on the agenda.
Yeah, okay. Gail and I got our agendas mixed up.
Oh, okay.
So I think this is the last thing we had on our agenda.
Correct.
So when we're done with this conversation, and I think we have a chairs meeting at 4.
Yeah.
So.
No, I would just say that I have a son-in-law who does a lot of IT stuff, and he works partly at MIT, and they're having the same conversation about how they're going to come back to school and be in classrooms, but be interactive. Some people would be remote. And I mean, I know I don't understand it at all, but he's got cameras that are like, this big that will see a whole room. I mean, there are ways to do this, and there are people who understand this stuff a lot better than you or I do, probably. And I think the technology is pretty amazing. So I think that we may find out that it is doable, but on a practical level, the politics of it is going to have to be discussed as well.
Yeah.
Well, I think one of the things that Lauren said at the very beginning, I think I remember you saying this, is that you have to first define what your policy is going to be, your philosophy behind what it is you want to do. And then figure out for those different levels, the committee rooms, the floor, public hearings, special committee meetings, caucuses, all of those different levels of things, what the philosophy is going to be for each of those. What's the interaction with people? What's the ability for people to watch? What's the ability for people to participate in each of those? And once you figure out that, then you can go start looking at the technology and the kind of rules around it. But until you figure that out, I think you don't know where you're going.
Sure.
I think I heard Lauren say that, not just like that.
I think you heard us say that. Yes, exactly. It's define the scope, and then the other questions of finance, technology, and rules will
follow
those.
Yeah.
Yeah. You said it much better and more succinctly than I did.
You did a great job, Madam Chair. Thank you so much for having us, even in this short time. We appreciate it.
No, that's great. And I know Amy had sent a note, so I'm glad you were able to come.
And give a big hello to Mark.
I will.
Yeah, really.
I missed him. It's just like, it's amazing to go from having people that you see every day, everywhere, and then.
I know. I'll pass that on. Thank you.
Thanks.
Thank you very much.
Okay, Chuck.
Thanks.
Thanks.
Amarin, we still haven't figured out yet whether this has to be a statute, it has to be a bill, or just I did send a note to the pro tem and the secretary, and I'll send them another note to ask them what their feeling is.
I think, Madam Chair,